if a crime happened here at my office, should the police be able to see the location history of every telephone in the vicinity? Should they be able to see who was in that apartment over there or the church down the road? What about every phone that was at a riot? What about a protest? That's the heart of an upcoming Supreme Court case about geofence warrants. And the story starts here with this map from the FBI. Near the center is where a bank robbery took place. When police came up dry on leads, they drew a large geographic circle around the bank and got a warrant that authorized Google to give them the location history of all the phones that had been in the area an hour before and after the robbery. So, swept up in the search was more than information about people at the bank. The geofence warrant covered an area larger than 3 football fields, so it also collected information from people at this church, and potentially at this restaurant, this hotel, and even people at this senior living facility. Now, on the one hand, the cops caught the criminal. On the other, they swept up the private information of innocent bystanders. Although Google has modified some of its policies since, at the time this case began in 2019, about 1/3 of all Google users, some 500 million people, voluntarily opted into using Google's location history service, which stores users' location information on Google's cloud. So, are geofence warrants ingenious or Orwellian, or both? And ultimately, are they constitutional? The Fourth Amendment bars searches of people, their homes, papers, and effects without a warrant. Orrin Kerr is a law professor at Stanford who filed a friend of the court brief siding with the government in this case. The scary idea is, well, this can be applied to protesters by ICE. It can be applied to Nina when she's out trying to find people to interview. The founder's intent was that you couldn't invade the privacy of the citizens who had not necessarily done anything wrong. So how do you deal with that?
The history of the disputes that led to the enactment of the Fourth Amendment were about how much cause does the government need in order to break into someone's home and rifle through their stuff. No one doubted that warrants could be obtained. It was just a problem that the warrants were too broad and obtained without enough cause.
So, how in modern times has the court thought about technological advances and the Fourth Amendment? For that, I reached out to Michael Dreeben. I turned to you because it's obviously your area of expertise. Dreeben served in the Justice Department for 31 years and argued 109 cases before the Supreme Court, most of them involving criminal law.
The court has, since the early 20th century, grappled with the problem of what to do with advancing technology that shrinks the area of privacy that the Fourth Amendment was intended to protect. And one can sum up those cases by saying it has uniformly favored privacy interests rather than extending analog precedents that allowed government searches.
This geofencing case is the latest clash between privacy and law enforcement. To better understand this case, let's go back to where that robbery happened. In 2019, a robber walked into the bank with a gun and soon fled with $195,000. Police interviewed witnesses and reviewed the bank's surveillance footage, where they saw the man who appeared to be the thief talking on his cell phone. But after 2 months, all leads had evaporated, so police applied for a geofence warrant directed at Google and its cell phone location information. A state magistrate judge found probable cause to issue the warrant for all the cell phone information within that circle. Google initially identified 19 cell phone users as potential suspects, but the company didn't identify those individuals by name. In fact, Google pushed back and negotiated with the police to reduce their request from 19 unidentified users to 9 and then just 3 cell phone users. Whereupon, Google agreed to unmask the identities of those 3 users, including Okello Chatri, who subsequently was arrested and entered a conditional guilty plea, allowing him to appeal. The other 2 identified users, as far as is known, were just innocent bystanders. And that's a potential problem.
They may have been going to church. They may have been going to a doctor. They may have been seeing a psychiatrist. They may have been visiting a lover. And they are swept up in the geofence because they happen to be there at that time, even though they have nothing to do with the robbery.
Geofencing can, in fact, sweep up lots of completely innocent people as suspects, and critics warn that it could be used by the government to spy on law-abiding citizens engaging in, among other things, lawful protests and political activity. On the other hand, as Drieben notes, geofencing was used after the January 6th Capitol riot. In that case, federal law enforcement authorities used geofencing to figure out which demonstrators clashed with police and invaded the Capitol, as opposed to those who were peaceably walking on the Capitol grounds. The Trump administration will tell the justices that because cell phone users voluntarily opted into the Google location history feature, they have no reasonable expectation of privacy with or without a warrant, especially when they're out in public anyway. Representing the defendant, lawyer Adam Unikowski will counter that not only is a warrant required, but the warrant in this case was insufficient.
The Fourth Amendment enacts very specific requirements for warrants. A view at the founding that it's oppressive to allow the government to execute general warrants, which is basically a warrant that allows to search everyone's house for contraband. We argue in this case that the warrant was unconstitutional because it allowed the government to search every single person's account, which is a little bit like searching every single person's house.
The government replies that it's only searching one place, Google. But Unikowski maintains that to find a needle in the Google haystack, Google has to sift through hundreds of millions of accounts. And that, he argues, is a dragnet, not a targeted search authorized by a judge.
They say that if you put data on the cloud, you've just given it away to the cloud service voluntarily, and therefore it's fair game for the government to come and get it. If that's true, then a lot of data that we thought was safe really wasn't.
But Michael Drieben, the Justice Department veteran, summarizes the counter-argument this way.
Here, the government's view is that Google is the place to be searched. It is Google's servers that have the information that the government is requesting. The probable cause comes from the fact that the robber was seen holding a cell phone, presumably talking on it, maybe to an accomplice, to a getaway car driver. The government had therefore reason to believe that if this individual had opted into Google's location history, this would be a way to solve the crime.
Ultimately, he says, the Supreme Court will have 2 basic questions to answer. First is whether a geofence is covered by the Fourth Amendment at all. And second is whether the millions of people who voluntarily signed up to have their locations tracked essentially gave up any right to privacy.
Even the government would concede, I think, that a travel diary like that, that's maintained for my benefit by a third-party collector of information that holds it for me, is protected against arbitrary government action. So the court has to decide here, is the location history database that Google is holding like a diary? Is it my personal information? Is it private property? And just as if I hired a storage unit to maintain the notebooks in which I kept personal notes, that would still be mine, and I would still have a privacy interest in it once I rented the storage locker and put it in. The argument is that this is the virtual equivalent.
This case is likely to be only the beginning of these kinds of cases. Google has tried to head off any problems by changing where location data is stored. Today, it's kept on users' devices, not on Google servers. But there are countless other questions that remain unanswered.
What else can the government do? Can the government go to a private facial recognition database and say, we have a surveillance photo of this suspect, please run it against your entire database? Can it do the same thing with DNA? Can it go to Anthropic and say, I want to know people who chatted with Claude about plotting revolution against the United States?
Google has filed a brief in this case that technically does not take sides, but it explicitly calls for a warrant requirement and takes the position that digital records should receive the same protections as physical records. Of course, Google is not the only tech company, and at some future point, the government might turn to other tech giants more willing to do what the government wants.